series with you guys. I'm going to do a little bit of a brief sort of background on everything, a little bit of the laws, what you need to know, and towards the end I'll go through the celebrities, and then I'll take Q&A. So I hope you enjoy the presentation, and please along the way, if you have questions, feel free to put them in the chat, and just in case you might forget them, and then I'll go through the chat list later and address as many questions as I can. All right, so quick little disclaimer. The contents of this presentation, as well as any answers discussed during the Q&A, are provided to you by way of general legal information only. It should not be construed as legal advice. If you need help with a specific legal situation, please consult with a licensed attorney. A little bit about who I am. I'm a working mom. I have 2 kids. I founded my law business in 2010, and I'm now a partner at San Martino and Sultan Law Group. So I'm also a business owner. And not only am I an attorney and a mother and a business owner, but I was a daughter to a mother who needed a Medicaid trust. So I've seen it from all the different angles. So I can also share some of my personal experiences with you guys. So where I like to start is sort of a general what is estate planning? Most of you know, you've seen TV, you know about a will. Estate planning means making a plan in advance that establishes who receives your assets, who would carry out your wishes when you die or become incapacitated. And it also includes financial and medical decision making if you become incapacitated. So I like to start with probate because this is where it all begins, especially if you don't have a plan. And what I like to emphasize for people, because most people don't realize this, is that probate, the whole surrogate court system, was designed for the purposes not of making sure your family receives their inheritance, but so that creditors get the first chance to reclaim the debts that are owed to them. Now, this goes all the way back to English roots when there was separation of church and state. Government needed to create a system for credit, free market economy. We want creditors to lend to people, but the creditors need to be able to have a way to reclaim their money when someone dies, and they could no longer go after the family members. So family doesn't have to pay the debts of their parents, but the estate does. So probate is the court process to admit a will to probate, or if there's no will, to go through the state's laws and make sure that money can be distributed after the creditors take their share. So I just like to make sure that people understand this because there's a lot of misinformation out there. A lot of people don't realize the family takes after the creditors. So a lot of times, the question becomes, well, probate, no big deal. I did a will, we'll put it through the probate system, my family will get their money. People don't realize in New York specifically, probate can take a very long time. We have 2 types. We have what's called small estate. If the total value of the assets are less than $50,000, that's called a small estate. And that's a simpler paperwork in theory, and it can take only a few weeks in New York. Specifically, I work in Long Island and the boroughs, so I'm specifically to that region. The other areas, sometimes further out, is less dense populations. The courts are a little bit more efficient, but at least in the cities and the city and the boroughs and the island, it can take years for some of the other stuff. So when we have anything over 50,000 is full probate, even if it's 60,000, it's going through the same long, complicated process. Sometimes can take months. The Bronx right now is the worst. It can take up to a year. Right now, like Queens and Brooklyn, for example, are a little bit faster. The other question is, what does probate cost? Certainly there's attorney's fees if your family's hiring an attorney. Most attorneys charge from $450 to $800 per hour, so costs to probate this will can easily exceed $10,000. There's also court filing fees. Shockingly, the surrogates court is the most expensive court in the state of New York. If the total value of the assets is more than $500,000, which most homeowners might be in that category, the filing fee is $1,250 plus a surcharge if you use a credit card. So you're looking at $1,300 just to get started in the process, not including legal fees, etc. Sometimes we see situations where the family doesn't have access to the money, right? Because the accounts are frozen when someone passes away. And they're saying, well, I need the money to pay the lawyer. And the lawyer says, well, since you don't have it, why don't we work out a contingency fee? Let's just use an example of 5%. If an attorney takes 5% and it's $1 million estate, now the attorney is getting $50,000. So we prefer in my practice not to do contingencies. We like, fees that people can rely on. But this is an example of what can happen without planning, and a will has to go through probate. A lot of people say, well, I've done a will. I'm done. I'm good. Can I avoid probate? And the answer is no. A will has to be verified by a judge. Your family can't take the will to the bank and say, hey, give me my money. They have no way to verify if it was correct, if everybody's been notified, if the person's even dead. So it has to go through the court system. And again, this is what causes all the congestion and delays with the probate process. If you're a homeowner, then someone else has to pay the mortgage until the house can be transferred. If you have a business, the business gets, shut down essentially. Nobody can access the bank accounts. If you are collecting rents, there's everything stops until someone's appointed through the court. And as I said, that can take months. So this is what we can lead to what we call waste, where the assets begin to waste because the expenses are increasing, but nobody's able to do anything to sell or transfer the assets. So probate can be a big problem. We actually think wills in some cases are worse than doing nothing because it just creates a problem. And the main thing you have to know is a will, even if you're disinheriting someone, the person that's disinherited gets an opportunity to come to court and dispute the will. So it's just a very problematic legal process. Of course, once somebody is appointed as the executor or the administrator, they can move forward, start collecting assets, start distributing it, but creditors always get first. So I want to make sure people know this information, spread the word, because there's a lot of people don't realize this. Hopefully your next thought is, how do I avoid this probate system? It sounds terrible. So here's the trick, right? So one thing you can do is create a trust and have the trust own your assets. For example, your house, your name on the deed is, the deed owns, excuse me, my name is on my deed, Leslie Sultan owns this house. When we create a trust, we do a new deed and it says the Leslie Sultan Trust owns the house. Same with bank accounts. Same with life insurance, right? We name the trust as the beneficiary. And then in the trust, we have the language. My house goes to my kids. My life insurance goes to my spouse. All of that goes in the trust. But the point is that the trust controls it, and the trust is a legal document that's binding and legally enforceable. And then all the trustee has to do once someone passes away is they start writing checks. So the trust maintains control over the assets during the lifetime as long as they're in the trust. And then if I'm the initial trustee, then I say in my trust, if I die or I become incapacitated, my next person is going to take over. And then when that step occurs, they just take over and now they're managing. What's not involved? A court, right? We don't need the court if the trust is drafted properly. So what is a trust? It's a legally binding written agreement between the creator of the trust, which we call the grantor, and the trustee. If we're doing a revocable living trust, for example, I'm both the grantor and the trustee. And then the trust provides a lot of legal protection for my assets, ensuring that I'm also the beneficiary. So everything in that trust is for my benefit. And then it has language: when I die, someone else is the trustee, and these people are the beneficiaries. So it's all in this one document. No court. A lot of people ask about asset protection. How do I avoid creditors? Can I do that? So a revocable trust is a powerful estate planning tool. It does avoid probate and it protects privacy. So again, a will is public. It goes through the court system. All of the celebrities that I'm going to tell you about later, I know about them because the court is public. And the minute something's filed with the court, TMZ and all the media are all over it and everyone gets to know about it. But a trust does not have to go through court, so it stays private. In some cases, there's tools for minimizing estate taxes. In New York, there's no inheritance tax, but there is an estate tax if you have over a certain number of millions of dollars. And again, as a trustee, I get to control my assets. So if I'm the trustee, I'm still writing checks. I can still sell my house. I can still buy a new house and put it into the trust. And it's not until I pass away or become incapacitated that someone else is taking over. At the point that someone else takes over, there is often asset protection. So for example, I can leave assets to my child. If they have special needs, I can create a special needs trust. They will never have direct access to the money, and it can never be touched if they're sued. So we also have something called a Medicaid trust. This does offer some asset protection specifically for Medicaid purposes. Medicaid is a government system that allows for people to, if they can't afford it, Medicaid will pay for their long-term care, nursing home, or staying in the home and having the aides come to them. The way the Medicaid trust works is I take all my assets, I put it into the trust, but someone else is managing it during my lifetime. So I'm not writing the checks, somebody else is. But because someone else is managing those assets, I'm protected. I qualify for Medicaid because I don't own anything. And Medicaid cannot go after those assets because it's not part of my estate. And Medicaid is only allowed to go after what they call estate recovery. So had it been in my name, Medicaid can come after it and reimburse themselves. If it's in my trust, they cannot. So it's a great way to avoid spending your life savings on long-term care and also ensuring that your loved ones will receive an inheritance without having to pay back the debt. So that's a great little tool for people. In case you're, want to know about Medicaid, how do you qualify? You have to be 65 years of age, blind, or disabled. You have to be a resident of New York for the type that we're talking about, and be unable to perform at least 2 activities of daily living. Those are bathing, toileting, grooming, dressing, eating, ambulating, and transferring. There is a needs base, so you have to have less than 32,000 and change in resources. So that's why we take the house and we put it into the trust. If you have a savings account with 40,000, you limit it to 32,000, and the rest goes into a trust bank account. And so obviously this stuff has to be done with someone with experience with estate planning, Medicaid trust planning, but when done properly, and we do these all the time, we save families a lot of money. The trick that I like to make sure to emphasize, again, is we want the trust to control everything. So the little image here is this girl with her little red wagon, and she's got all the toys in the wagon, right? So a trust can only control what it owns. So when she grabs that yellow handle, she's pulling the cart with all of the toys in it, okay? We call this funding the trust. So you have to put the assets into the red wagon. If you don't do that, then the assets outside of the wagon still have to go to court even though you have a trust, right? So setting up a trust, just to be clear, is a 2-part process. And we've seen, unfortunately, where people create a trust, they put the house in, and then they never get around to transferring the rest of the stuff, and then it's still in probate. But the idea is we want to avoid probate, put everything in the cart, and then she's controlling the cart, and when she passes away, the person she's nominated now controls the cart. If it's not in the cart, got to go to court. Then the court will put it into the cart, but we're trying to avoid court. All right, so on the topic of estate planning, I don't want to overlook some of the bigger topics that are also really important, which is healthcare plans, healthcare directives. So there's 4 that I'm going to talk about: living will, healthcare proxy, HIPAA, and power of attorney. You're probably familiar with a lot of these. Just to briefly go through them, a living will, not to be confused with a last will and testament, which is very similar sounding, is in the event that you're in a vegetative state and the only thing keeping you alive is medical intervention, life support, etc., do you or don't you want it to be continued? So it's really important to be able to have this document, especially if you don't want it to be continued. You'd want it to be withdrawn because then your family knows. These are difficult conversations to have. I understand that, but it does give your family peace of mind and the assurance to know how to make that decision and not fight about it between themselves or, just to know. I had to unfortunately go through this with my mom recently, and she had a living will, and she said, do not resuscitate, all of this stuff. So I was, when you have to make those tough decisions, and it's nice to see it in writing because it's confirmation. Healthcare proxy, probably some of you have filled this out if you've ever had a medical procedure. You're appointing someone to make medical decisions for you in the event that you cannot make those yourself. So, we are autonomous individuals. Nobody can make those decisions for us, not even technically a spouse. So it's really great to just have this document in place. You pick, agent number one. If agent number one's not available, agent number two. HIPAA forms are great to fill out because if you have an agent who's going to make these decisions, they need access to your medical records. As some of you may know, that's not easy to get access to someone else's medical records under the HIPAA laws. So if you sign a HIPAA release and appoint them as an agent, they're able to get access to those documents. Power of attorney. So power of attorney is a very powerful document. It enables you to appoint someone to make financial, business, and other legal decisions for you. Essentially with a power of attorney and you become incapacitated, the agent can go into your bank account and start paying your bills for you, making legal decisions for you if you needed to be transferred to a nursing home or a facility. And of course, you do want to be careful who you give this to because in theory, they can go in and take all the money out. But it's a very powerful tool. And if you don't have a power of attorney and you lose capacity, in the state of New York, we have to do something called a guardianship proceeding. And if you haven't heard about what those are, they are a court process where somebody is declared incompetent and they determine who's going to manage all of their stuff for them. It's a very invasive process. A lot of attorneys are involved, a lot of court people. They're looking at medical records, financial records, going to the house. And it can get very expensive and just not, it's just, if you fill out a power of attorney and you sign it, it takes 30 minutes. Otherwise, you're in court dealing with these awful guardianship proceedings. So wherever possible, we want people to avoid having guardianship by doing a power of attorney. So again, power of attorney is you need it in case you become incapacitated or unable to manage your own stuff. It can also be used if you're going to be traveling out of the country. We saw during COVID, people got stuck in other countries. And so how can we pay the bills? How do we manage businesses? So it can help with that. It can also help in a physical incapacity. If you're stuck in a hospital and you need someone to go run into the bank and do something for you, the power of attorney can do that. And of course, a mental incapacity, if someone's in a coma, Alzheimer's, dementia, stroke, and they're not able to do it themselves. So that's the estate planning 101, guys. So I think I gave you the full background. So now we'll go into the, oops, that's going too fast here. Whoa. Let me see. Go back a little bit. So let's go back to, oh, sorry, guys, technical difficulties here. All right, I don't know what to put in here. So we've got Jimi Hendrix. Are you guys seeing my screen? I don't know if it's.
We're seeing your version of it.
Okay, we might have to stay there. So Jimi Hendrix died in 1970. He was 27 years old. Now, Jimi Hendrix did not do an estate plan. Not surprising, I'm sure. So in what happens when you don't have an estate plan is the state that you live in declares how the money is transferred. So for example, in New York, if you have a spouse, everything goes to the spouse. If you have a spouse and children, everything's divided 50% to the spouse, 50% divided equally among the children. If you have no spouse, then everything to the children. If you have no spouse and children, it goes up to your parents. If you have no parents, it goes to your siblings. If you have no siblings, it goes to nieces and nephews. No nieces and nephews goes back up. They try to find is a whole hierarchy. So in Jimi Hendrix's case, he had no spouse, no children, and so everything went to his father. Now, Jimi Hendrix did have a brother. They were both in foster care together, and so they were close. Apparently, this was not there was a bunch of other siblings who were adopted out. So everything you want to know about Jimi Hendrix family. So the father inherited everything. Now the father, his name was I forget, but Leon was the brother. Father inherited everything, and father managed the estate. So he managed all the royalties. He did everything for Jimi Hendrix's estate, and he did an estate plan. So when he died, he left everything he owned to his adopted stepdaughter. Okay, he completely disinherited Leon, Jimi's brother. So essentially, everything that Jimi Hendrix owned and could have gone to his brother now went to a daughter, an adopted stepchild that he never knew. So this is kind of unfortunate. Leon tried to sue. He tried to, claim some of it, but because there was no estate plan listing him, he received nothing. So that's a bad story. All right, so now let's go to Sonny Bono. Sonny Bono also did not do an estate plan. If you remember, he died in a 1998 ski accident. He had no will. He was only worth about $2 million at the time that he died in 1998. He was married to his fourth wife, so she became the administrator of the estate. And he also had a couple of children, one with Cher and one from a previous marriage. Then this kid comes forward and he says, Sonny Bono is my dad, and I want to share. So the court said, well, you have to do a DNA test, and then he disappeared. So that ended that. But it created, lawsuits for the family. Then Cher sued Sonny Bono's estate, saying that he owed alimony from years before. She sued for millions of dollars. At the time, Cher was worth 300 million. So this is kind of like, wow, she must have really had a vendetta for him. Fortunately, that I guess for her or for the other family members, she didn't win on the lawsuit claiming the arrears, and everything was divided equally between Sonny's fourth wife and the two children. So that's the story. Obviously, that could have been avoided had he done a trust. So, but because he didn't, everything had to go through court, public knowledge. All right. So let's talk about some celebrities who did do an estate plan, because we do want to acknowledge people that did it and did it right. So Rosa Parks, she's a great example. As you know, she was a part of the civil rights movement, civil disobedience on the bus. She died at the age of 92, and she did a will and a trust in her 80s. Now, Rosa Parks unfortunately had suffered from dementia, Alzheimer's later in her life. And there was actually some contest by her family that she didn't have capacity. But the good news is that she did a will. And in her will, she left a ton of civil rights memorabilia, letters, photos, etc., to a charity that she had created. So this is good news, because now this stuff is preserved, that had it been gone to a niece or nephew or something, we don't know where it would have wound up. So she was able to make sure that these great, historical memorabilia went to a place that can benefit us. She, in her will, just so you know, she left 90% to a friend, 10% to her nieces and nephews. So they, of course, sued wanting more. There was a settlement in that. And again, they claimed that she was unduly influenced by this friend. The takeaway on this one, just so you guys have an idea, is because she didn't do her first will until she was in her 80s, had she done it earlier in her life and maybe updated along the way, it would have been a stronger argument for this was her wishes, right? But when you wait too long and you don't do like see a doctor and make sure the doctor can confirm that you have mental capacity, then it becomes challengeable. All right, the other fun one that I like to talk about is Hugh Hefner, the founder of Playboy. Now, he had a wife and 4 children at the time that he died. He did a trust, and but for a tiny little one thing was left out of the trust. And because that, remember, we talked about funding the trust, moving everything into the wagon, because he left that one thing out, everything had to go through court. So when it went to court, it opened up, the trust became public. Now, Hugh Hefner apparently spent a lot of time with his trust. He hired the best lawyers, and his trust has actually become like a template for people. They like the language that Hugh Hefner used. So, for example, one of the things that his trust is applauded for is having a substance abuse clause. Why he needed that, we don't know, but he said if any of my children or the trustee, he left everything to his children in trusts. So the children get a trust and then they could manage their own sub-trusts. But he says they can't manage it if they're using drugs. They're going to have to take mandatory drug tests. If they are, they have to be removed and they can come back a year if they've been sober for a year. So, that gave him some control and reassurance that his money wasn't going to be spent for drug abuse. He also put it in an interesting clause, and I'll read it to you. It says, I expressly disinherit and exclude as beneficiary any person who claims to be my child, unless such child lived with me in my household and was acknowledged in writing to be my child. So this is really strong language about disinheritance. Most of the time we just kind of put, we leave I have 2 children and I leave everything to my 2 children, or I specifically disinherit child 1 and everything goes to child 2. So, but him and his attorneys were able to craft, sort of preventing, as we saw with Sonny Bono, these people that come forward and say, yeah, I'm his kid, I'm entitled to money. So he's saying no. So there's a lot you could do with estate planning. Obviously, there's a lot you can prepare for. There's a lot of family dynamics. Every family is different. So we always want to make sure, that we plan properly. And as I think it was Benjamin Franklin said, failing to plan is planning to fail. So that's my slideshow, guys. Do want to give you guys an opportunity in case anybody's interested in using our services. For taking the time to attend today, we would give you a $500 discount on any trust plan with us. I will leave my contact information here. My office is in Garden City. I'll open it up for questions, but this, for taking the time, you learned a little bit about it. I'll have to spend less time during a consultation with you, so I appreciate the time saved, and we do give a discount for attendees. So I will check. I don't see anything in the chat in terms of questions. So if anybody wants to unmute themselves and ask a question, I'm happy to answer.
Yes, please do, or put it into the chat. Leslie, that was fantastic, very interesting. Really appreciate it. And I do have a question,
Sure.
couple questions. So the thing that occurred to me as you were talking early on, are there such things as like, death scam? Like, today there's so many scams going on. It just seemed to me when you said, well, the court opens everything up, like that these fake creditors would come along and start claiming that they're real creditors. Do you see that happening?
That's a good question. So what happens through the courts is I don't see a lot of scams because the creditor really is going to have to document any actual credits, any debts, I'm sorry. So, and in fact, what I do see is, for example, somebody might have a credit card debt with like one of these smaller companies. So there might be American Express, Chase, and then maybe, I don't know, Barclay. And so once we file a probate petition, it's public record, and some of these credit card companies somehow are able to dig into the database, and so it immediately alerts them that a probate has been filed. And then they'll file something with, almost like with the court. They start sending notices, these official notices. Those official notices are what becomes payable. So in other words, creditors only have 7 months. They have to file their claim within 7 months. If they miss that date, they lose their claim. So that's, in some ways it's good because it cuts off the time from when creditors can come. So we might see 3 credit cards that are owned by the person who died, but only 2 of them use the database. So there's a possibility that one debt doesn't actually have to be paid, only the 2 that put the formal notice into through the courts. So we could see claims from other, scam artists. But hopefully if it's being done through the courts, the court will protect them. They'll say, show us the proof of the debt. They have to come through and do all of show the documentation. And hopefully if someone's using an attorney, the attorney will say, well, no, that's not the official notice. You can ignore that.
Okay.
So, but that's a good question. Yeah.
Very good. Thank you.
All right, there's some in the chat. Will you please post your contact information here? Sure, I will type that in. I'll put my website. And I'll put my email. And my phone number. That should help. Okay. Oh, Bruce, someone said I can't hear Matt. So yeah, he's having some microphone issues. But his question, just so you know, was, with all the scams going on today, how do we prevent that in the probate process? So hopefully my answer clarified that. Someone's asking, does the rule of guardianship in the United States, is it recognized in another country? That's a good question. I'm only licensed in New York. I can only, do New York and New Jersey. I think it might be country dependent. So, technically New York doesn't have jurisdiction outside of New York. So if there's a court order that says, this person has lost capacity, the daughter is the guardian, we would hope that that would be sufficient. But unfortunately, we can't control how another country is going to receive that. Another example that we've seen, for example, is like in some countries, Jamaica is a good example. I could do a will and I could say, I leave all my property to my children here in New York. But in Jamaica, if the children are not Jamaican citizens, they're not entitled to own land. They have to be a citizen of the country. So that's not going to apply. So I would have had to do another estate plan in Jamaica and make the relevant designations based on the laws there. Okay, so question, does probate apply to hospital bills and student loans as well? Any creditor that wants to come after the estate, 100%. I don't know that I've seen student loans for any of my clients. So, again, the trick is that the creditor has to know that the probate has been filed and they have only 7 months to put in their claim. So my suspicion is the schools don't use the database. Some hospitals do, but some don't. So, when it comes to probate, you're only responsible for paying the creditors who file the formal notices. And a lot of them, and at some point it gets cut off after 7 months. You found out too late, sorry. It's a public court. You should have been paying attention. You missed it. You can't go after the debt anymore. Okay, so someone says just having a will and other information is not enough to be secure. So, I would just say a will is a legal document. 100%, if you have a valid will and it's probated properly, your beneficiaries are going to receive their inheritance. But the main point that I like to drive home is a will has to go through probate. The biggest time we see this as a problem is if you're a co-op owner, right? So you have monthly maintenance due every month and nobody has access to your bank accounts and the will is going through probate. And that could take 6 months. So 6 months of arrears are going to accrue for the maintenance. And then the person's going to be appointed. They're going to say, okay, now I have the right to sell this apartment, but the co-op's going to take 6 months of arrears plus late fees back because they weren't paid on time. And if we had done a trust, we would have had the immediate authority to list the house, the apartment and sell it. So, it can be enough. The other way to avoid probate is naming beneficiaries on all your accounts, right? So if you have a bank account with a joint owner, it automatically goes to the joint owner. If you have a bank account with beneficiaries, when you pass away, they submit the death certificate, they fill out a claim form, and they receive the benefit. There's no court. Those are like third-party contracts. Those are legally enforceable. A will cannot change a beneficiary, and therein lies the problem. Sometimes people don't update their beneficiaries, right? They might put their spouse, then they get divorced, they forget to change the spouse on the bank account. Or they're young, they get a great job, they get life insurance through the job, they put their parents on the beneficiaries, then they get married, forget to name the spouse as a beneficiary. Or worst of all, we name a minor as a beneficiary in a life insurance policy. Minors cannot legally fill out a claim form. So now we're stuck in through the courts, and the courts have to get involved. This is literally the worst thing you can do for with these in this process is name a minor as a beneficiary on a life insurance policy because they can't fill out the claim form, and the only way the money can go to them is through what's called a custodial account through the courts. And trust me when I tell you, you do not want a judge overseeing the money for the children. That's not how we want these things to go. So beneficiaries is at least like a last ditch effort, but it's not the best way to do estate planning. Alternatively, you can name a trust as the beneficiary on the accounts, especially when there's minors. And then the money goes into the trust account, and then the trust holds the money until the kids reach a certain age and can buy them things and spend the money for their health, education, etc. And then when they reach a certain age that you designate in the trust, then they receive their money.
I'm showing Leslie stalled. I don't know if that's me or
Did I lose you guys?
yeah, for a second there.
Okay. If I need to repeat anything, please let me know. I don't know where it got cut off.
Although actually, it's my computer is saying mine is unstable, so maybe it was just me.
Oh, okay. Uh-oh. All right, let's get you stable there, Matthew. All right, so the next question is, I have a will, healthcare proxy, and power of attorney in place. What's the point of the trust? Again, that could work for you, but you have to understand that the will goes through probate. The will does not act on its own. So as long as you're okay with the will going through probate, paying the court filing fees, knowing that your kids are going to, the people that you love who are inheriting have to pay those fees, wait out that process, possibly hire an attorney, then maybe you don't need the trust. Again, the people that need a trust, especially are for Medicaid planning, right? Because you don't want you want them to qualify for the long-term care, and you don't want Medicaid to come after the assets. If you have a co-op and the co-op can own the shares of the trust, if the trust can own the shares for the co-op, that's a great tool for co-op owners. Also a will, okay, so will, healthcare proxy, POA, yeah. So it just really comes down to, do you want to keep your family out of court? We say a trust is a gift that you give your family because you keep them out of court, you taken care of all of that. Another problem we see is, great, you did a will, everything's going to go to your family. Where is everything? Is it organized? Does the family know where your banks are? I had a client die. The wife had to figure out where all the money was. She had to drive to every single bank and say, do I have an account here? Because she couldn't find any documents. And she found 14 different accounts and she didn't find them all in time. And some went to unclaimed funds. You know, you got to be really organized to do it right. The other thing I will mention on that topic is if you have beneficiaries listed and your beneficiaries are receiving a government benefit like disability or Medicaid, and they receive an inheritance, guess what they lose? The government benefits. And then they have to spend down all the money in order to get back on the government benefit. So the beauty of a trust is it has what I call magical language that protects beneficiaries in these cases. So, you know, every family situation is different. Every estate planning should be different. So, Imogen, if you feel like everything I've mentioned today reaffirms that you have what you need, then that's great. Congratulations on getting those done. If you have any of these other complex scenarios that you might want to reconsider a trust or at least have a consultation with someone. Okay, so someone's asking if all assets are owned jointly and one spouse dies, wouldn't all assets automatically be transferred without a will? That's 100% correct. In fact, a will wouldn't be able to do anything when there's a joint owner. Okay, but not everything can be jointly owned, right? So it depends on the dynamics, the setup. But if everything is jointly owned, 100% everything goes to the surviving joint owner. Then the question becomes, does the joint owner have an estate plan? The surviving owner. Because if there's no joint anymore, when they go, everything is going to go through the laws of the state of New York. So in some cases, it's good to plan while both are alive so that when the second to die passes, everything is set up for that second person. All right, another question. If you have one kid and everything is left to them, isn't that enough? I went to probate based on a family advice and in turn spent a ton of money. I do not want the same thing to happen to my kid. So if you only have one kid and everything is left to them, that sounds like a great plan. The only time that's going to be an issue is what if something happens to the kid? Okay, so two things. One, they could be alive, but they could be injured or on disability, or they could be getting sued by someone. In any of these kind of complex situations, the money is not going to go to them. It's going to go to their creditors. Or if you don't have a plan that says what happens if my kid dies, where does the money go? It's going to go through the state system. So then they're going to look to your parents. Are your parents alive? Are your brothers and sisters alive? Next thing you know, what you meant for your kid is now going to that sister that you hate, right? So you kind of have to take it one step further. And in your will, say, if my kid is not alive, I want it to go to this charity or this church. You know, you have to be able to foresee a little bit more than just that one transaction. And again, what if the kid is disabled? You know, if he's receiving any kind of government benefits and he receives the inheritance, he loses the benefits. So, you know, hopefully none of this happens, right? But as an estate planning attorney, we see when things go wrong. We see what people didn't plan for. So my job is to try to educate people about how we can prevent some of those things that we didn't think about. Okay, someone's asking, what about an adjunction to a deed that goes to probate too? I'm not sure what you mean by adjunction. I'm not, Nadine, if you could clarify your question, because I'm not right.
Hello, Leslie and
Hi.
everybody. Sorry. I just wanted to know, like, an injunction, because I have a situation. I'm talking to attorney. Basically, they said an injunction is that would be an addition to a deed. Would that eventually, in my case, if need to go, because it seemed like a lot of things go to probate if you don't have a trust, would that can then tell to go to probate, an injunction to a deed? I don't know. That's what he was saying to me. An injunction. If this
I don't,
person pass on, the other person gets this. If they joint on a house.
I don't know what the word adjunction is. There is something in law
Maybe
called an injunction.
maybe that's what I meant. I don't know. A
But an
junction.
injunction is where the court is intervening, like to stop something, which I don't see how that term is applicable in what you're talking about.
Oh wow. Okay, that's
So,
when he was telling me a junction, something like that. I just wanted to know if that's
so
what.
okay, so if a house, if you, I'm going to tell you guys a little thing that most people don't know.
Hmm. Thank you.
A house is called real property. All right. So technically, under the law, if the only asset is a house, the law says that real property passes to heirs upon the death of the owner. So if the only asset you have is a will, it's actually better to not do a will. Wait, did I say that right? If the only asset you have is a house, it's better to not technically do a will, because if you do the will, the house has to go through court. The judge has to have jurisdiction to appoint someone to transfer the house. If you don't do a will and the only thing you own is a house, technically your heirs, your spouse and children automatically receive it when you die.
Oh wow.
But does
Thank
that mean
you.
you have no cash, no bank accounts?
Right. So that's like if you know the bank, if you have a bank account, you'd have to have a beneficiary that's going to receive it. If you
Mm.
don't have a beneficiary, you're still in probate. But technically a house can pass if that's the only asset to the heirs. We do what's called an heirship, an heirs at law deed transfer. And I've seen a lot of unfortunate situations where lawyers are probating a house when they shouldn't be. And I think it's because they don't know. There's a lot of myths around estate planning. But if you work with a title company, we work with a title company. Some of them require the deceased person to be dead for 2 years before they'll do a deed transfer, because they want to make sure anybody who could say that they're an heir can come forward. We work with title companies that don't require that because we have a good relationship and we meet their needs instead, their requirements. So if it comes to a house, again, maybe speak to another estate planning attorney, get a second opinion in your specific situation. But if there's a will, my friend, one of my friend Janet Nations always says, where there's a will, there's probate. Okay, so if you do a will, it has to go through the courts. If you don't do a will, that might have to go through court unless you have a beneficiaries listed. Another fun fact, in New York, we created something called a transfer on death deed, which essentially puts a beneficiary on a house. Okay, so this is good news-ish. Okay, it just came out last year. It's a brand new law, which means it has flaws. Okay, so we in the estate planning world are not recommending a transfer on death deed without getting into too many details, because it hasn't been fully developed. It has to go, there has to be litigation. It has to be it was pushed through Congress a little too fast, and so there's a lot of flaws, so we don't like it yet. But there is a possibility, hopefully, once this gets kind of flushed out, to add a beneficiary on a house. And the whole point of that was to avoid expensive estate planning for people who really can't afford it. Some people have a house and not a lot of money, so to go and buy a trust can be a burden for people. So this is the idea with the transfer on death deeds. I do not recommend them yet. Like, they've got to kind of it's got to marinate a little while longer. But hopefully in a couple of years, that would be an option for families. I'm going to go on to the next question. I've made you look at this differently. Thanks. I see a new truth aspect. Oh, good. My job is to educate and empower people. Hopefully that helps you guys make better decisions. Where were you when this happened to me and my mom? She did not want to do the will, but her sister encouraged her. And you're right, it was a nightmare. I'm really sorry to hear that. Unfortunately, yeah, probate can be a nightmare. So she had to probate, and the stupid will, the stupid will that you find online and left me out of it. Oh no, there's a lot of legal stuff going on here. So I'm sorry this happened to you. I'm glad I'm able to help in a little bit of ways. I'll be honest, we don't like wills. As an estate planning attorney, they can create a lot more problems. We have a situation where grandma wrote a will and she left her New York house to two of the New York grandchildren because all the other grandchildren were in Puerto Rico and she never saw them. So the problem is with the will, we had to notify all the other grandchildren. We had to let them know and give them an opportunity to come to court and dispute the will if they wanted to. Now they didn't, but we had to find them all. We had to send them notices. There was 26 people, guys, because some of the cousins died, and then we had to let their children know. It was insane. It was such a bummer. If she had just done a trust, bam, the house would have been done, sold, done. It was, the will creates so many problems, guys. Okay, so someone said I'm right about putting minors on a deed. Yeah, you can't put minors on a deed. You can't put minors as beneficiaries. And don't do the thing where it's like, oh, I'll put my sister. She'll take care of my kids. I'll tell you one example when that's not a good idea, because sister could die, unfortunately. And then all that money in her account that she's managing for your kids goes to her husband. Okay, we don't recommend that at all. A trust can be costly. What's the best option? So yes, I'll give you the breakdown. For example, if you come to us and you say we want to do a will, our fee is $2,000. We do a package, a will, power of attorney, healthcare proxy, etc. So $2,000, you get all of it. But remember what I said, your family has to probate that will. They're going to pay a filing fee, possibly $1,300. They might pay a retainer to a lawyer. Most lawyers want at least $5,000. So now all in, you're at like $8,000, right? Now just to probate this will. Okay, so you save money in the beginning, but the family now pays for it later. A trust, for example, we charge flat fees as well. For an individual revocable trust, they start at $5,000. Okay, so it's a little bit more than a will. Again, that's a package. Trust, we give a backup will, power of attorney, healthcare proxy, but then the family doesn't pay anything. It's all they do is submit the death certificate to the bank. Now they're the new trustee, write the checks, list the house for sale, sign the deed, done. Because the trust owns everything. There's no fees. There's no court. Again, it's a trust it's a gift you give your family. Obviously, that's not always affordable for some people. See if you can find an attorney that does a payment plan. We always do payment plans. We do at least half and half. For people that can't afford it, we do a further breakdown. We never want someone to not do an estate plan that's for their family just because they can't afford it. So we like to work with people, make sure you're looking for an attorney that can also work with you. Okay, so we're getting more horror stories from Emojine saying her tax bills were high, the minor child, they lost the house. Will the trust also enforce the beneficiary that you list on insurance policies, or do you have to state that in a legal document? Right. So again, to be clear, when you have a life insurance policy, it's like a contract with this company, whether it's Northwell or New York Life. So when you have an agreement with them, you list the beneficiary. That's between you and them. The trust doesn't get involved, and nor does the will. However, we recommend, if you've created a trust, that you name the trust as the beneficiary. Then you submit the death certificate, they write a check to the trust, and the trust has all that language. When I die, I want everything to be distributed equal to my children. If my children are minors, let's hold it until they're 25. I have a great story. How much time do we have? I got 5 minutes.
A couple more minutes.
Whitney Houston had an estate plan. Throw in another celebrity estate. As you know, Whitney Houston was married to Bobby Brown. They had a child, Bobby Christina. They got divorced. Whitney Houston did a will in California because her daughter was a minor, and she left everything in trust to her daughter. So a trust was created when she died. Her daughter was under 18 when she died, so the money went into the trust. And her trust said, I give her a portion at 18, a portion at 25, and the balance at 30. So we call this a distribution schedule. So it's broken down. And then the trust said, if my daughter's not alive, it goes to my siblings. Whitney Houston had 2 brothers. So, as you can imagine, when Whitney died at 18, the daughter got a big chunk of money. As you may know, Whitney Houston's daughter died at the same way that she died, unfortunately, and she was 20 years old when she died. So all the money that she inherited, where do you think it went? She did not have an estate plan, by the way, the daughter. So it went to her father, Bobby Brown. Okay, so not what Whitney Houston wanted for Bobby Brown to get more of her money. And he had his own money. You know, he was plenty wealthy. So unfortunately, a big chunk of the money went to Bobby Brown. But the saving grace of this story is that Whitney had those 2 other distribution ages, 25 and 30. So 2/3 of the money was held in the trust, and because the daughter died, it went to her siblings. So this is a good story in some ways when it comes to minors. Good quick question. Is putting a home in a trust, does it affect your mortgage? Great question. No, it doesn't. So under the law, Congress passed a law in the 80s called the Garden-St. Germain Act. And it says that you're not allowed to, under law, you're not allowed to transfer your house without the lender's consent, essentially, except when it comes to a trust. So the transfer to a trust in a house that you're living in, your primary residence, can 100% be transferred to the trust without the lender's consent. And the lender cannot recall the loan or enforce the due on sale clause. So great question. I guess our time is up. I'm happy to stay on for a few minutes, but I don't want to take too much time from
Let me
people.
ask one more question before we wrap up. You mentioned early on, Leslie, about small estates, people with less than 50,000. What about people in, say, in New York who have lived their adult lives in rent-controlled apartments? So they don't own any real property, but you know they're doing fine. But in that situation, is a trust as necessary?
Yeah, good question. So the question for those that couldn't hear, Matthew, is that what if you don't own a house, but you have a rent-controlled apartment? Congratulations to those that do for your low rent. Do you need a trust? So I would probably say no. We wouldn't recommend a trust if you don't have a large amount of assets. You know, if all you have is a bank account, ideally all you're doing is naming a beneficiary on that account. Assuming that account is larger, you know, you have hundreds of thousands, you can name a beneficiary. But if the beneficiary could have an issue, so the beneficiary has special needs, has a disability, could pass away, then you might want to consider a trust for the benefit of the beneficiary, but not for the apartment. If you don't own the apartment, so then it passes under succession law. If someone's living there, they can take over. Otherwise, goodbye, wonderful rent controlled apartment.